right, I'll go ahead and begin the introductions. We are starting the session for the need to expand genetic non-discrimination laws. Per our discussion, our prior discussion, we definitely see where some of those needs lie. So I'd like to introduce Mark Rothstein and Rosario Isasi. Rosario is a research associate professor of human genetics and an adjunct professor of law at the Dr. John T. McDonald Foundation Department of Human Genetics at the University of Miami Miller School of Medicine. Her research is devoted to identifying and analyzing the social, ethical, and policy dimensions of novel and disruptive genetic technologies. Mark Rothstein is the Herbert F. Bale Chair of Law and Medicine and Director of the Institute of Bioethics, Health Policy, and Law at the University of Louisville School of Medicine. Professor Rothstein's research focuses on the legal and ethical issues of genetics, health privacy, and public health. He's currently leading an NIH grant study on the regulation of international direct participant genomic research. At this point, I will turn it over to both of you. Thank you for joining us.
Thank you.
Thank you.
Shelley, could you stop screen sharing? There we go.
What do I?
Start your show. You want to start your show?
Yeah.
Click on show. Show.
Good afternoon. Can everyone see my slides? Oh, that's great. So I'm going to speak for the first 20 minutes or so about genetic non-discrimination laws, the federal law, the GINA Act that many of you are familiar with, the Americans with Disabilities Act, and some state laws. And then I will turn it over to my friend and colleague, Professor Isasi, who's going to talk about the importance of genetic non-discrimination legislation for people who are in racial or ethnic minority groups. So let's start with the famous signing date, May 21st, 2008, when GINA was signed. And I'll just identify a few people on this picture if you're not familiar with them. Obviously, that's President Bush signing the law. On the far left-hand side is former Senator Olympia Snowe, who was the chief Senate sponsor. Over her left shoulder is Mike Leavitt, who is a former governor of Utah, and at the time of the legislation was Secretary of Health and Human Services. In front to his left is former Representative Louise Slaughter, who is really the driving force behind this legislation. And she passed away in 2018. And on the far right side, second from right, is Dr. Francis Collins, who at the time of the signing was the director of the National Human Genome Research Institute, and the next year was appointed director of NIH, and that's a position that he still has. So if you would see the results of the vote in the Senate and the House, you might initially think, wow, isn't that wonderful? There must be this tremendous consensus that this legislation ought to be enacted. Well, on a cynical day, you might say, how good can this law be, where it passed both houses of Congress and there was only one no vote? And I'm usually compelled by the cynical argument, and when we review the actual statute, you may see why. So the original bill was introduced in 1995, and it took 13 years before it was enacted by Congress. And the reason was that there were parts of the bill that were controversial, and they were taken out, and it went through the entire legislative sort of sausage-making process. The interesting thing about this law, or one of them, is that unlike other civil rights laws, there was not a history of tremendous discrimination against people on the basis of their genetic information. This was, in a sense, a way to try to preempt those kinds of actions and to give individuals the confidence to take advantage of genetic testing and genetic technologies and so forth. And we're going to talk about how that plays out in the context of genetic screening for all sorts of disorders. GINA, as it was enacted, applies only to genetic discrimination in health insurance and employment. There are many state laws that are quite similar. 48 states, in fact, prohibit genetic discrimination in health insurance, and 35 prohibit genetic discrimination in employment. GINA does not cover or apply to life insurance, disability insurance, long-term care insurance, mortgage insurance, auto insurance, flood insurance, all sorts of other things you might put up on the screen, as well as education, commercial transactions, and even real property transactions. So the law has two main titles. Title I, the first part of GINA, prohibits discrimination in health insurance on the basis of genetic information. And it's important to take a look at this three-part definition of genetic information. It includes an individual's genetic tests, the genetic tests of family members, and the manifestation of a disease or disorder in a family member. So it would be my genetic tests, the genetic test of my family members, and perhaps the family health histories of relatives where they might show that a parent of mine, for example, died of Huntington's disease. Now, if you look at that, you might ask, okay, what is missing? Individual's genetic test of family, but only the manifestation of disease in a family member. So what's missing is the law doesn't prohibit discrimination based on an individual's own health history. And Congress was not prepared to enact legislation prohibiting discrimination in health insurance based on pre-existing conditions. 2 years later, however, when the presidency changed, when Congress changed, Congress was prepared to enact the Affordable Care Act in 2010 that prohibits discrimination on the basis of any pre-existing condition, genetic or otherwise. The other important definitional section for us to think about is the section that defines a genetic test. And the statute says the genetic test is an analysis of human DNA, RNA, chromosomes, proteins, or metabolites that detects genotypes, mutations, or chromosomal changes. When we apply that test, however, it doesn't apply to some of the things that we might like it to apply to. For example, it wouldn't apply to epigenetic marks. Why? Because an epigenetic test is not a test to measure human DNA, right? It's the chemicals that rest on the DNA and determine whether the DNA is going to be expressed. Similarly, microbiome data would not apply because microbiome data is not human DNA, right? It's the DNA of all the organisms in various parts of the body, such as the gut. And so I think it illustrates that GINA is frozen in time, meaning it's a definition that was developed by NIH for Congress in the early to mid 1990s. And all you have to do is think about where we are in scientific discovery in the last 25 years to realize that, well, maybe that needs to be updated to be more comprehensive. The second of the two main titles of GINA prohibits discrimination in employment on the basis of genetic information. GINA, however, only applies to individuals who are asymptomatic. If you are symptomatic, then you might have coverage under the Americans with Disabilities Act, which applies to individuals who have impairments that constitute a substantial limitation of a major life activity. I tried to illustrate that on this slide. And if you go to the bottom, we start with GINA, and we're working from not affected to most seriously affected. If you are asymptomatic, GINA would apply to you. But if you were symptomatic, which the statute calls manifestation of disease, you're out of luck in terms of GINA. The ADA, however, would not protect you at all while you're asymptomatic and would only protect you if you had the manifestation of disease. The problem is it's not comprehensive. When you put these two laws together, there's a gap in the middle. And to give you an illustration, suppose you were starting to show the mild symptoms of ALS. Would you be protected by GINA? The answer is no. Would you be protected by the main provision of the ADA? The answer is also no. Theoretically, you might be able to make an argument that you were regarded as having a disability if you had mild symptoms. However, the problem with that is that has really not been tested in the courts. I know of only one case that has been decided on that basis, and that was a district court, a trial court decision. And besides that, even if you were held to be protected by the ADA because you were regarded as having a disability, under the ADA, if you're covered by the so-called regarded as prong, no employer or other covered entity is required to provide reasonable accommodation. And you may need that reasonable accommodation if you have some early stage of a disorder where you can work if you're accommodated, but you can't work without accommodation. For example, you may need to have your hours limited. You may need to have restrictions on the requirements that you travel for your job and things like that. Now I want to switch to genetics and life insurance, which is an issue that I've been working on for 25 years and that I'm working on with Professor Isasi at the moment, and she'll bring you up to date on those things. The states have enacted some laws to seemingly protect people from discrimination in life insurance on the basis of genetic information. There is no federal law, of course. And let me tell you a little bit about those state laws. 9 states provide that the use of genetic information in life insurance must be actuarially justified. These laws have no value. The reason I say that is all 50 states have enacted laws that say that any insurance product that is sold within the state must be actuarially justified. So adding a separate statute for genetics and life insurance does not advance the cause of genetic non-discrimination. 8 states require informed consent before genetic testing for life insurance. That sounds appealing, but there are over 800 life insurance companies in the United States. To my knowledge, and I've been studying this for a long time, there are no insurance companies that require genetic testing, and therefore a statute requiring informed consent doesn't really help you very much. California has a law that prohibits discrimination against unaffected carriers of recessive disorders. Again, like the first category, that would be not actuarially justified, and that would be prohibited without that statute. Similarly, in North Carolina, discrimination on the basis of sickle cell trait or hemoglobin C trait would not be actuarially justified. Therefore, you actually don't need that law. An interesting law was enacted in Vermont that prohibits genetic testing as a condition of applying for any type of insurance. or using the genetic test of family members. Well, that seems pretty good. Prohibits genetic testing as a condition of applying for any type of insurance or using the genetic tests of family members. However, this law may still exclude from, a life insurer may still exclude from coverage or charge higher rates based on the results of genetic tests performed in the clinical setting and documented in the applicant's medical record. And that is the main problem that these laws need to address. Fortunately, one state has done so. And on July 1st of 2020, Governor Ron DeSantis signed a law that made Florida the first state to prohibit life insurers from using genetic information, which by statute is defined as the results of predictive genetic tests. They can use it for people who are already diagnosed, but this kind of predictive genetic testing is now prohibited by Florida law. And this law went into effect on January 1st of 2021. I've been arguing that these kinds of laws should have been enacted long ago. And this is one of the areas where we might want to try to work to try to get legislation in the other 49 states. I've argued unsuccessfully, unfortunately, that genetic discrimination in life insurance is an invasion of privacy because life insurance companies who are not covered by the HIPAA privacy rule are getting all this information of a sensitive nature about individuals. I've argued that it's unfair because many people want to protect the financial security of their loved ones, and they're being excluded from having access to this. I've argued that it lacks underwriting utility, and it's a complicated explanation of why that in fact is the case, but most genetic tests did not support discrimination in underwriting. I pointed to the fact that the United States is really an international outlier in this area, that the UK, Canada, Australia, France, South Korea, there's a whole long list of countries that have successfully enacted legislation prohibiting genetic discrimination in life insurance. And the life insurance companies there have not gone out of business, and they have survived quite well. And I've even argued that it's a violation of medical ethics for physicians working for life insurance companies to go along with getting access to the genetic test results of individuals. The most powerful argument that has not yet been adopted is basically this, that without legislation prohibiting life insurers from using the results of genetic tests, at-risk individuals are discouraged from predictive genetic testing. If you spoke to genetic counselors, if you spoke to clinical geneticists, they would all tell you stories about their patients or clients who have decided not to be tested, even though there was a family history and it might be valuable, because they were afraid of the social results, meaning access by life insurers and other insurers to that information. Whereas if predictive genetic testing were more common, it would promote greater prevention, surveillance, earlier diagnosis, earlier treatment, and reduced mortality. So I think you could very convincingly argue, I hope so, that enacting this kind of legislation will save lives. And what more could you argue to a legislature than that? Well, at this time, I want to switch to the argument that some at-risk individuals are even more reluctant to undergo predictive genetic testing, and those are people who belong to racial and ethnic minorities. And my colleague, Professor Isasi, will pick up our argument at this point. Thank you.
Thank you.
Thank you, Mark. I'm gonna share my screen, and I always face me some tricks, but let's see if I can get it. Bear with me. I think you can see it now on the screen. Resume share. Is sharing okay? Oh yeah, I see it. Thank you. So when we talk about disparities, oh, my screen is paused.
I'm not seeing it.
Yeah,
We
I
don't
don't
have
know. It is now.
Well, I see you, but not you.
Oh, okay.
There we go.
There we go.
We see it.
Okay. Voila. Thank you. When we talk about discrimination and we talk about equity, etc., one of the important aspects is that how we fit all the pieces of the puzzle together. So I want to walk you and trying to connect the different aspects that where health disparities, genetics, and ALS connect. Right? And first is the context. There is an elephant, as I call it, that never left the room. And I think every time we talk about biomedical research, but particularly genetic research, we have to acknowledge what I call it the legacy of the past. A two-pronged system. One, a history or a record of historical abuses in biomedical research that started, we know from the Nuremberg, from the Nazi experiments, but even more contemporaneous, the Guatemala studies, the Tuskegee studies, Henrietta Lacks, the HeLa cells that are famous in cancer, the Hasupavi case, that these are genetic Native Americans participation in genetic research, and the lack of knowledge and context of the cultural difference that dictates how to frame and move forward research projects. So, in this record of historical abuses, we have also history disenfranchisement. So meaning vulnerable populations not only necessarily being exploited, but also excluded for participating in research. That brings three core lessons that translate now, that are current now. One is that the broad representation in the studies and then challenging the generalizability of research findings and including the medical practice, what I will talk now, and is a legacy of mistrust in the medical system, mistrust in the law or the legal system to adequately protect them. So health disparities, how did they occur and why? So first, health disparities doesn't necessarily mean that we account for all health differences or that all important health differences that warrant specific attentions are there. Our more narrow approach to issues of systematic, plausible, avoidable health differences that adversely affect disadvantaged groups. And this disadvantaged group don't necessarily have to be from ethnic or ancestry minority. There are many factors that foster health disparities. Some of them, they're causal relationship that we can see it. Social, environmental factors directly impact, exposed, living in a low-income neighborhood where there are more toxin exposures, right? More pollutants. There are related correlations with certain poor health outcomes. There are others that are not that quite understandable or at face value acknowledged, and there's ancestry, right? Cultural aspects, social aspects, unequal distribution of resources. There's a number of factors that appear. But one that is very germane also to this, to the topic we're talking about, familial illness and the genetic component we were talking about, is the context of genetic disparities. And this is because there have been, up to now, a missing diversity in human genetic studies. The broad database of genetic findings have been based on individuals for European ancestry. What it means that there are enormous implications for risk predictions, right, of difference across global populations. We know that there's a pattern of genetic variations among populations that, as I said, affect disease risk, but also affects treatment efficacy and safety, pharmacogenomics, right? So this bias in what I call and this is a very interesting study that look at genome-wide association studies and what is the category of genes that we have, translate into poor disease prediction. and treatment for individuals, and mostly important for underrepresented populations or ancestries, but also equally important, as I said, to everybody, because it impedes our availability to understand the architectures of genetic disease that ultimately lead to an increase in understanding of precision medicine and medical care. Right? I give you an example. When a number of genetic studies, one of the puzzles is variants of unknown significance, right? VUS. How do we know that a VUS is a real VUS, or whether it's pathogenic or not? When looking at individuals of different ancestries. If that VUS is prevalent and there's no disease present and no risk of disease, we can understand that, oh, really, this VUS is noise. It's not pathogenic. It's not a VUS of concern. And there's many examples of that. So I'm not an expert in ALS, but I was looking at what I make some connections with health disparities, right? When we talk about this genetic map of the world population with so many missing pieces that really will affect how we move eventually for uptake in genetic and in improvement in disease treatments and diagnosis and therapies, from which we want to access and protect, and what genetic anti-discrimination laws plays a role. So I was looking at one of the studies. This is the National Longitudinal Mortality Studies that look at the incidence rates in ALS. So the number one lesson here was, oh, okay, ALS is less frequently in African Americans as compared to Asians and whites. And then when we compare it with Hispanics and non-Hispanics, it's less prevalent in Hispanics, right? So we said, okay, it's a disease that occurs predominantly in white and or European ancestry. But then if I remember these lessons about how our genetic map of knowledge is biased with lack of representation for other ancestries, then it is reasonable to say that we lack a precise understanding of racial and ethnic variations in ALS that might help reveal candidate for future disease studies. So I can understand better, or researchers, the etiology and the disease progression. So there's this correlation, right, of health disparities can impact everybody and this recognition. So I'm going to show you, well, a genetic disability-based discrimination and affects everybody with ALS, at risk of ALS and their families. But if we know there's a record of higher discrimination for racial and ethnic minorities, right? There's racism, then it's most likely that these populations will be more affected by discriminatory practices. And I know this is what we're going to discuss at the last session. So here's another example. I look at the surveillance project. The surveillance project was very interesting study to look at, evaluate whether the US National ALS Registry was complete or not, how the completeness. And it looked at passive and active registration in the registry. The lesson was here that of the cases they don't know much, that they were not represented in the registry, whether passive or actively, were more likely to be not white, Hispanic, less than 65 years old, and Western state. So it was said, why? What explains this lack of representation in the registry? And what we find is very connected to what the elements we find in health disparities research, right? Lack of access to specialty clinics, access to care, access to technology. So in the registry is mostly self-reported or requires self-registration by using computer and internet. And individuals with low socioeconomic status have demonstrated to be less likely to have access to these technologies or to use those technologies. Access to Medicare or social disability insurance with different eligibility criteria, or lack of knowledge they can have access to these benefits. So we can see how in ALS, these gaps could and still be prevalent. When we talk about genetic non-discrimination law, we are starting by thinking that genetic medicine, we put our hopes in genetic medicine to help find cures for the disease. So what are the barriers to implementing general medicine and how they are germane to this issue of health disparities? First, to identify them, this is an interesting study by Moon Curry from the CDC. We can see there are different cohorts, right, by stakeholders. From the patient's and relative perspective, awareness, knowledge, access, family dynamics, they're all interrelated. There's another set of the stakeholders that we talk about, healthcare organizations, laboratories, about coordinating across the specialties, having EHR records centralized. But for the policymakers, for the government level, one is the policies, the actual laws, and state programs that promote uptake in access to genetic testing. This seems very clear, right? But this is the problem. Okay, we said we have identified the barriers, then we can tackle them. It's not that simple because those barriers are quite complex. They change and evolve over time, but also these barriers vary between themselves and within the variations. And a clear example is awareness of genetic testing in underrepresented communities and different ancestries, because they're not monolithic. If I talk about the Latinos with my ancestry, we are not monolithic. So within our groups, there will be difference. And they will depend on acculturation, nativity, and how we perceive ourselves, like our sense of identity. Another example I can give you that is also related is cascade screening. And here's when directly have been identified in several studies the effect of genetic privacy and the discrimination state laws, and I said also the federal law. So if we talk about barriers, let's look at how the concerns about accessing genetic testing and the implications of that have. This is a study that in the Middle East, and I'm bringing it up because I want to correlate it one part of the extreme of the world then to the US. And they look at what are the concerns of healthcare practitioners and patients to the application of genetics in the clinical setting. If we look at them, cost, we can relate to that, right? Of course. But if we look at the other columns, these are the 5 or 6 top criteria. Stigma associated with discrimination, right? And then we see the consequences then we use of genetic testing. Discrimination in the employment, discrimination in the insurance, and then correlated with privacy and protection. Now, let me take you to the US. What is the study US said? This is a study in the US, again, barriers to the use of genetic testing, and it particularly look at racial and ethnic minorities and disparities there. Number one, the prediction, it was lack of knowledge. Second, we talk about concerns about misuse, right, and last, trust in medical care and clinicians and the healthcare system. When I talked earlier as an introduction of the legacy of the past, we see here clearly replicated in a study. This is 11 years ago, but we were going to run this study now, we find the same result. This belief that the legal, the social, the healthcare system can protect these individuals enough so they can confidently seek the care and the treatment they need, including genetic testing predicted. Most of the studies have been done in these communities in the cancer setting, predicted genetic testing. But I think the result could be extrapolated for many other areas of research. And we anecdotally, in my department, we run a very successful genetic clinic. We see this every day for a gamut of neurological and other conditions. So what are the barriers and most concerns of minorities or in general of the public? On one hand, we saw the barriers of precision medicine, access, cost, but awareness is high. Awareness of the test itself, but also awareness of legal protections or lack thereof. So this is several studies of Latino, that's here. There was a very important take-off message, Latinos and Blacks. I mean, the more participants were educated about GINA and genetic and discrimination laws and privacy protection, the more likely they were to gain confidence in the system and increase uptake in the testing. So the barriers to seeking predicted genetic testing decrease. They were not eliminated, but decreased. That leads me to a very important issue that is very correlated with health disparities, is literacy. And in our session earlier, we talk about that, is the knowledge of individuals, enough knowledge of individuals about how to obtain, how to process, and how to act on into medical information to predict. Health literacy is not monolithic. It's not only related to patients and research participants. It's also going to be translated in healthcare professionals. The most impactful aspect of health literacy, I would say, is empowerment. It's allowing individuals to seek interventions for health promotion, and to probably also catapult physicians to go peer-to-peer. These are two very interesting studies about the level of genetic literacy in healthcare providers, not geneticists, regular healthcare providers. In one, we see how the level is quite low. Well, there's some knowledge about whole genome sequencing, and they use technologies and some basic genetic principles. But look at the second column when the study is looking at reported understanding of evaluating the knowledge of GINA protections, right? Basic knowledge and limited knowledge. Nobody ranked high in this study. And that's quite concerning. The healthcare providers are going to promote uptake of predicted genetic testing. It's a living a confidence to the patients, or in the clinicals or in the research setting for investigators and research participants about the limits, but also the benefit of testing. What is the ultimate goal? What all this matters, in my humble view, is because this is about health equity, right? If we are looking at a term that have a level of health for all people, we have to focus on avoidable inequities. And we have to correct the record. We have to move from disenfranchised research participants to move to a culture of participatory research where everybody has a seat on the table. So research, disease communities, participants, individuals with different ancestries, and everybody should now be more empowered to be participant in research without concerns of what will happen if I do. Genetic anti-discrimination policy and laws have a systemic effect, will have a systemic effect of this, right? And to avoid health disparities, to correct the record so the discoveries of today in genetic medicine and others could really be actionable for everybody. So I want to leave it for questions now. Thank you.
Okay, thank you both so very much. It looks as though we do have one question that was submitted already. Jean asked, do you think laws seeking to rein in coordination between mass testers like 23andMe and insurers are sufficient?
Well, actually, the concern about 23andMe and other genetic testing companies sharing results with life insurance companies was the reason that the Florida law was enacted. However, there's no evidence that that information is shared. So if you won't tell anybody, I will mention that the Florida law, as great as it is, was sort of enacted by mistake. 23andMe is very good about not sharing information. I think they recognize that they would go out of business if they had a reputation for sharing people's information without their consent. If you've taken a 23andMe test, you may recall there's a separate form that you sign if you authorize them to do research with your results in a de-identified form. And certainly one of their business models is to sell that information to pharmaceutical companies and the like. But I know of no situation in which they have sort of irresponsibly and in violation of their contractual agreement disclosed people's health information.
And also, what I will add, we don't have data whether there's a greater uptake of direct-to-consumer genetic testing in Florida. So Florida is going to give us, I hope, a wonderful natural case study of a genetic and discrimination law. Florida is a minority, as you know, the ancestry is predominantly Hispanic or Latin American, I would say Hispanic of Latinos, but also Blacks that are not necessarily African Americans for the Caribbean. So culturally, it's quite interesting. They show higher levels prevalence of cancer, and that it will be interesting to see whether the effect of this of the new law affects the uptake in different types of predictive genetic testing. But also we have very low levels of health literacy in our state, including of the genetic discrimination laws and others. So we wonder what will be the actual practical effect of this law. It is something that will be rarely unnoticed, or will be something that will create a nice model for other states and the federal government to replicate.
And their follow-up in regards to that is asking whether clinicians are informing people of the new protections in Florida.
Rosie?
Well, Mark and I hope they will be soon. We have some grant spending on this, but I can say that at least some institution we are. The law got us by surprise. We lawyers like to have those updates of legislation, so it came to the inbox that this have happened. We didn't even know there was much debated. It just passed as a surprise for everybody. And then we started in a campaign to educate in our hospital system. University of Miami has a big healthcare system with different hospitals and, as I said, a clinical division that with all the most of the genetic consults in the state, and to educate them and to start telling in our clinic, genetic counsel and others, that this law exists, but it doesn't come effect on July 1st, if I'm not correct. So it's coming, but we don't know the effects yet. How will replicate at the state level this level of necessary educational campaign? We don't know yet.
Does anyone else have any additional questions? Doesn't
I
appear
just had
Okay,
a
go
quick
ahead, Jen.
one. As attendees, what can we do, or any action items for us that we should take away from this to help in our own states? I mean, it sounds like Florida, there's been some progress, but how about other states? What can we do?
Well, it's an area where not one single, genetic disease group or illness can really get the results. I think you need to work together with all the other entities, the Genetic Alliance, the American Cancer Society, all these other groups. And if you get together with them, then I think you can make a more compelling case to members of your state legislature. And of course, what you need is a champion or two, and someone who really believes in the cause and is going to work for you.
I agree. And the other issues also a broader agenda, right? And include many voices and many faces when you reach participants. And when I talk about genetic disparities, health disparities, and all these issues, it might feel foreign to the topic of genetic and discrimination laws, but I think it is, because it situates the context in which it's occurred to promote uptake, to promote the research agenda. But at the end of the day, the laws will not be effective if we don't have more people undergoing genetic testing, right? Without fear. And acknowledging these legacies of the past, these people that will have the lack of mistrust, they will be the less likely to that uptake is important.
Thank you so much for both of you working so hard on understanding this better and educating people about it. I know, for instance, in California, even I reached out about about getting the Florida law passed, and the legislative director for my state senator was like, "Oh, that's already illegal in California." And then I was like, "No, it's not." And then he was like, "Okay, you're right, but didn't something get passed last year that did it?" You know, but it was more of a privacy kind of law that got passed last year in California that doesn't quite address what happens when you have knowledge from a research test or something like that. So it's not quite perfect. So I think it's very great to popularize what the best practices are.
Well, let me add that California is the only state that prohibits genetic discrimination in housing. And so we need to give them their due. And I hope other states enact those kinds of laws, and we're working on it.
I don't want to spoil something I was going to say later, but just for folks who are on now, you know, there's no harm in talking to people. One of our team members was friends with a state legislator in Georgia and shared the news article about Florida. And this gentleman introduced a copy of the bill in Florida in the Georgia State Assembly. I see it hasn't had movement in many months, so maybe it's dead, but it was great to see that just some simple conversations can get the ball moving.
Fantastic information. Does anyone else have any additional questions? Then again, I want to thank both you, Professor Rothstein and Professor Jean's clapping, Isasi. Very, very informative, helpful. Agree that we truly appreciate the fight that you're fighting for individuals like us.
Thank you. Our pleasure.
Thank you for your time.